Well done on Module 4, and welcome to Module 5. In this module, we explain the Opacity Playbook, how transparency gets blocked, how intimidation works, and why this accelerates grand corruption and state capture. Why does transparency matter? The answer is visibility. People can see decisions, money flows, and reasons. When transparency is real, corruption is harder to hide. When transparency is blocked, corruption becomes safer and easier to scale. Opacity is deliberate. It can be a deliberate governance choice to reduce visibility, reduce scrutiny, reduce consequences. One common tactic is secrecy around money. Procurement is high risk because it moves large public funds quickly. Opacity can look like restricted tenders, thin evaluation records, confidential contracts, or large variations after award. When records are weak, accountability becomes opinion, not evidence. Another tactic is using law as a shield. Some governments and powerful actors use laws and legal threats to silence the critical voices of journalists, civil society, and those who request information. Transparency International has often described how laws and imitation tactics can be used to silence critical reporting on corruption. Foreign agent and funding restriction laws are used to create and attach a stigma to groups and individuals who seek transparency. This is a common pattern globally, where laws that stigmatise civil society or independent media, often forcing them to register as foreign agents or by restricting foreign funding. C. Vickers describes foreign agent laws as measurements that stigmatise civil society and independent media by framing them as serving foreign interests. The effect is often a chilling one: fewer watchdogs, less scrutiny, and higher corruption risk. Let's look at a global example involving Russia and their foreign agent laws. Human Rights Watch has said Russian authorities have used foreign agents laws to smear and punish independent voices. UN experts have also described sweeping restrictions being used to silence human rights defenders, journalists, and civil society. The learning point here is not politics, it's pattern. When scrutiny is labelled as disloyalty, transparency collapses. Our second global example is from India and involves claims of restricting civil society funding. The UN Human Rights Office reported concerns that the Foreign Contribution Regulations Act, or the FCRA, has been used to justify intrusive measures such as raids, freezing accounts, and suspending or cancelling registrations of civil society organisations. Legal organisations have also criticised the law's impact on civil society space. Our third and final global example, although there are many more, is from Hungary. Hungary's sovereignty law has also drawn criticism. Reuters reported the Council of Europe's Venice Commission warning the law could suppress free and democratic public discourse. And they also raised concerns about independence and arbitrary application. Separate legal analysis notes EU infringement proceedings and Venice Commission recommendations relating to these provisions. There is an intimidation toolkit that corrupted states often use. Opacity isn't only about laws, it's about intimidation. Transparency International notes that defamation lawsuits, often called slaps, are increasingly used to harass, intimidate, and discredit those who speak up. They also describe the high cost journalists can pay when reporting on corruption, including legal risks and intimidation. The purpose is simple: make scrutiny feel personally dangerous. Let's look at a scenario and see if you can identify the tactics being used. An NGO publishes evidence about a procurement deal. Soon after, their funding registration is suspended. They are labelled as serving foreign interests, and a defamation lawsuit is filed. What tactics do you hear? Well, you're hearing three tactics: restricting information, stigmatising scrutiny, and weaponising legal pressure. So what safeguards can reduce opacity risk? 1. Open records and access to information. 2. Transparent procurement and contracts. 3. Protected speaking up, safe reporting and anti-retaliation. 4. Limits on legal harassment, including anti-slap protections. 5. Independent oversight that can act without fear or favour. That's a wrap on this module. Remember this key takeaway before the knowledge test. When systems punish scrutiny, corruption becomes safer. Transparency is not a slogan, it's a control. If you can't see decisions and money flows, you can't govern them.